so we should all be able to stay bright and alert after lunch. Just a couple of things to remind you. Number one, these arguments are streamed live on the Appellate Court's YouTube channel. So that means whatever you say goes out everywhere into whatever the internet is, to the ether. So think before you talk, which is good advice anyway. But remember, no take-backs. Secondly, for the appellants, when you come up to give your argument, after you give your name, please tell us if you wish to reserve any time for rebuttal. You may reserve up to 5 minutes. If there are no announcements or introductions, let's begin. Would you call the first case, please?
Travelers Property Casualty Company of America versus Gilley Construction, Inc.
Good afternoon, and may it please the court, Grant Reese on behalf of Gilley Construction, the appellant. I would like to reserve 4 minutes of time for rebuttal.
4 minutes, okay.
The trial court erred when it granted an offensive summary judgment in favor of the plaintiff appellee, Travelers Insurance Company. Travelers argued to the trial court, and the trial court apparently accepted an argument that at the summary judgment stage, the burden in a class code insurance audit dispute shall be placed on the non-movement, here Gilley Construction. That decision flies in the face of the plain language of Rule 56. By way of extension, the trial court applied a case from this court, the MVT Services case, which relies on different facts from that present here, in ruling that the insurance company only has to make a reasonable determination. In applying those facts, the trial court stated and concluded that based on a number of factors, that Travelers was entitled to summary judgment. To have been entitled to summary judgment, however, Travelers would have had to prove as a matter of law that class code 5222, which is a higher class code resulting in a higher premium, applied as a matter of law. The language utilized in the policy for applying that did not use a reasonable standard. Instead, it uses the term proper. And the term proper logically indicates that Travelers would have had to prove that 5222 is a proper, not merely a reasonable standard. In addition to this, the trial court also concluded that other factors, including the omission of optional WH-347 forms, as well as the failure to exhaust permissive remedies, made Travelers have an automatic win at summary judgment. Those issues are incorrect and are due to be reversed.
Counsel, do you dispute that the opposing party, that the Travelers is entitled to those forms and they've requested them, you haven't provided them? Aren't they entitled to them under the terms of the agreement here?
Judge Usman, the timing at which Travelers requested these is important. Travelers requested the WH-347 forms months after the audit actually took place. So the audit took place and a person from Travelers actually came to Gilley's office in Manchester, Tennessee, and conducted the audit. Months later in December was the first time that Travelers ever asked for those WH-347 forms. So timing is important. And on the timing issue, Gilley Construction actually has said we will provide these forms, but it's 7,000 pages of documents and they have to be hard copied. In addition, they have to be redacted to remove sensitive personal identifying information, namely social security numbers. And that was done in January of 2020. Again, months later after the audit had concluded. This was in the audit dispute process.
Do we have any findings from the trial court here addressing your timing concern in its final order? I don't remember anything in the order that addresses the timing concern that you've raised.
The trial court did not address the timing concerns. What it said was that that was a factor in concluding that Traveler's audit premium decision was reasonable. But the WH-347 forms themselves provided no additional information that Travelers didn't already have that was provided through both the audit itself and the initial phase of the audit dispute. And so the information contained in those forms would have been merely redundant information. And so to the extent that those forms make a difference, they're merely redundant. And Travelers has really not shown or proven that the failure to produce those forms prejudiced them in any way. And certainly they haven't argued nor shown, and the trial court didn't find that the failure to produce those forms made a material difference into how the court actually ruled and why those forms would have made a difference in the decision. And back to, on the timing front in particular, Gilley Construction offered in January, and they indicated to Travelers in an email that it was 7,000 pages, and only 10 days later did Travelers unilaterally decide to end the audit dispute process. Instead of waiting on Gilley to provide those forms, they said to end it, and they opted to proceed with litigation to begin with.
Are there any material facts in dispute here?
The material facts in dispute.
I mean, it seems like everybody agreed these forms were prepared off-site and then taken to the bridge or the place where the interstate bridge was being constructed. So, you know, don't we all agree what the material facts are?
I think we do, Your Honor, and that leads to a great point. The procedural posture of this case is important. We agree on what the bridge work was done. There's no dispute as to that. This was done off-site, not more than 10 feet above the air, which is what that higher class code would dictate. That's not in dispute. I think the only dispute in the dispute of fact here, because it's a summary judgment, is whether or not Travelers proved as a matter of law that they were showed to the trial court that the determination of 5222 was correct.
Counsel, doesn't Travelers raise concerns, though, about daily documents related to the daily work that's being done by your employees and whether they were actually at the site or not, or am I mistaken in that regard? And isn't that part of the contention here, that you didn't provide certain records of daily work performance that may have indicated some sort of work being done at the location of the bridge itself?
Two things on that, Judge Usman. Importantly, Travelers indicates in its brief that there were these individual daily worksheets that were not provided, but that's not correct. What Shantae Gilley, who's a principal of Gilley Construction, testified, and this is on page 35 of her deposition, which is in the record at page 466, she testified that the individual worksheets, she began developing that system in 2020 after the relevant time period of the Birmingham job. And so we would contend that there couldn't have been a failure to produce documents that didn't exist in the first place. More importantly, in December of 2019, during the process, Gilley Construction, by way of an email, in addition to all the documents that they had produced to the auditor in person, they produced QuickBooks exports that showed by color code what employees were doing what type of work. And here, there's no dispute that the job was performed off-site at the casting yard. The undisputed testimony here from Robert Gilley is that the workers were never on the bridge site itself. The bridge site was actually 4 to 5 miles down the road. And that was intentionally done for two reasons. One, as a matter of efficiency, but more importantly, relevant to this court's consideration, is that was done to mitigate the risk that all the workers' compensation carriers who were insuring various subcontractors on the Birmingham job faced. Here, Gilley Construction was working on the ground. They were tying steel. And steel reinforcement is the actual term used in the subcontract. The scope of work for Gilley under the subcontract, which is at page 89 of the technical record, says install steel reinforcement. Code 5213, which is the lower risk code that Gilley had applied initially, expressly includes steel reinforcement as a part of that class code. 5222, on the other hand, does not mention steel reinforcement. What it does mention is that if you're not working on a bridge that's over 10 feet in the air, you redirect the classification back to Code 5213.
So there's no doubt, there's no dispute that Gilley's people never went to the bridge site.
That's correct, Your Honor. That's the undisputed testimony. That was based on both the testimony of Robert Gilley, and that was based on photographic and videographic evidence that was produced and that's on the record in this appeal.
Then what is the reasoning for applying the 5222 category?
Travelers unilaterally applied the 5222 in its audit. And in fact, the reason that they did that is that they apparently had found, doing internet research, that this payroll was allocated to the Birmingham job, and they went on the internet and found out that this was the 2059 bridge construction through downtown Birmingham. And so they didn't use, it appears, at least from the record, Travelers did not use the tax records, payroll reports, contracts, or any of the other documents that the policy language indicates from which they would make a determination about the proper class code. Instead, the only evidence in the record from which that they determined that code to apply was that they found that this was a bridge job, and they did that from the internet. None of the Gilley records themselves indicate that they were ever on site, and the undisputed testimony, along with both the video and photos that are on the record, indicate that they were never on the job site.
We have some dispute here about what version or of the 5222 code description applies here.
Judge McBrayer, that point is one is interesting because the language relied on by Travelers in its motion for summary judgment is the same language we relied on in our appeal. And that's what was it really wasn't relied on by the trial court, because the trial court never made a determination that 5222 was the proper class code. I understand Travelers' position in its appellee brief that it may not be the updated code, but it's the code they raised to the court as being the updated and correct code from which they would make their decision about this case. And I see my time is running short. One other consideration here is the administrative remedies issue. That was a factor in the court's decision to grant summary judgment, but that, I think, is undisputed, that the language may in that statute that applies to the administrative remedy issue is a merely permissive statute. And to consider that as a factor for granting summary judgment here would effectively judicially rewrite the statute to a mandatory language. And so if Travelers is able to use the failure of Gilley Construction to exhaust its administrative remedies, the trial court and this court would effectively rewrite the statute from may to shall. Thank you.
Thank you.
Good afternoon, Your Honors. Ben Rose on behalf of the appellee Travelers. I want to step back for a moment and talk a little bit about the facts of this case, because I think they are important, and I don't believe they got mentioned in my friend's opening argument, which is what this work concerned. This was, as a self-described in the record, massive interstate bridge project in Birmingham, Alabama. It's the I-59 I-20 interchange. I'm sure Your Honors are likely familiar, as I am, traveling in the Birmingham area with this type of interchange. Significant, I think it's about 2.5 mile section of bridge interstate that was being constructed. It was, and as reflected in the record, related to about $1 million in premium that was effectively subsidized by the WCIP, Tennessee's assigned risk plan. And as we've referenced in the briefing materials, I've had a significant involvement in that plan back when it was called the TWCIP, now the CIP, WCIP administered by the NCCI. there's a significant history of the way this unique insurance product works. Gilley's essential theory here is that so long as all the work took place on the casting yard, they should be entitled to the lower code, the 5213 code. Our position, and Judge McBrayer, I heard a question about whether or not there's a disputed issue of material fact, I think related to whether or not these folks were on the casting yard. That really was not an issue that we got to. And frankly, it's not material with the way these types of insurance projects work. And that's because the higher class code takes into consideration work that's connected with the on-site type activity that was going on the actual work site itself. So even if we assume that there was a separate casting yard and that no one ever strayed into the actual work site itself, it wouldn't make a material difference as it relates to the way the policy works, because that code takes into consideration work in connection with those types of activities.
How far does that connection concept extend? And if I'm a cement company and doing mix and I'm never, I bring it to some off-site location, am I connected to the bridge project? I mean, does any work at all connected to this project fall within that higher code?
I think the court is guided by what the code says within 5222 and also what is not said within 5213. If you look at 5213, it specifically references not otherwise classified. The more appropriate code, which is what was in the international nutrition case, which we'll talk about, I'm sure, in a moment, that kind of code is the more appropriate code for that work. The court is also guided by the scopes manual in that regard, Your Honor, the Bible of the way these codes work. So yes, if you're in connection, let's say it's 10 miles away from the work site itself, because it's connected with that type of work, you're automatically assessed the higher code, not because that's the way Travelers wants it, not because that's the way the auditor wants it, but because that's the way the policy works in terms of the class codes themselves, as set out by the NCCI and the scope manual, which again is the Bible.
So under that scopes manual, Gilley's would be charged for a heightened level of, lack of a better word, danger in the work, even though they didn't do that.
Well, again, the court is assuming that they didn't do that. We don't know exactly what the work was, and I don't think it matters, frankly, because of the way that the codes work. But if Gilley was to come in, and much of the argument we've made, if Gilley wants to come in and try to prove that the specific type of work that they did, they can come in and show evidence of that. Just the same way that this court did, not just at the time Judge Kirby wrote in the MVT case. It's the same situation with the Texas drivers, right, in MVT. So in MVT, we had drivers that were based in Tennessee that drove all over the country and were incurring risk on a Tennessee insurance policy, the same way that the risk is being incurred in this particular case. And those folks wanted to come in basically and have a mini trial after the time of audit and say, oh no, you have to look, insurance company, at every individual driver in each specific circumstance to determine what their risk is. And Judge Kirby looks at that and looks at...
Isn't Gilley arguing here that none of their employees were engaged in that process? None of them were 10 feet in the air or 20 feet apart, and so none of the employees were and maybe there is an underlying factual dispute here as to whether that's actually true or not. But if we're assuming, for purpose of argument, that it's not, doesn't that make this case distinct?
From MVT?
Right.
No, Your Honor, and actually it makes it worse, because that was MVT's argument. And as I was going to say, Judge Kirby goes on to look through the contract, the insurance contract, and says, look, this is not a forum. You don't get to litigate after an audit individual driver's status. And then she goes back and looks at, well, what was your position? Well, your position was the same as the insured in this particular case, Gilley. You said all these folks were Texas drivers, and they were all Texas risk. And so we're going to look at the provisions of the policy, and we're going to find as interpreted through Tennessee workers' compensation law and the other precedent that's on the books in this regard that we've litigated over many years, and we're going to find that this is actually Tennessee risk. It is the same rationale. They say, well, let's just assume that we never went to the casting yard. It doesn't make any difference. I admit that their argument might be a little better. I guess it might be more equitable for them to come in and try to prove to some court that what these individuals were doing, but they didn't do that. And in fact, not only did they not do that, they refused to produce information that was requested, both in the time of audit and at the time of the audit dispute, and up until including this proceeding that we're in front of today.
They refused to produce what information?
Specifically, Your Honor, at the time of audit, and remember the MVT, Judge Kirby's decision teaches us that that is the time. If you are going to distinguish your risk from the way the policy works, or the way the codes work, for example, in this instance, at the time of audit, you have to produce every available piece of information that will help your argument in that regard to be assessed. And then there's a whole procedure that you can go up administratively or ultimately be sued, as Gilley was in this case, and challenge those designations. The only thing of significance, Your Honor, that was produced as part of that process was during the audit dispute process. Gilley produced the color-coded spreadsheets. Now, these were spreadsheets. There was a large compendium of spreadsheets that were based, according to Shanta Gilley, who was the person in charge of the paperwork, as I understand, for Gilley. These spreadsheets were color-coded by Gilley itself to determine what these folks were doing at whatever given time. They were based on QuickBooks reports that were never provided to travelers at time of audit, at the time of trial, or summary judgment, or in this proceeding. Those QuickBook documents were, according to Ms. Gilley, also based on daily worksheets these individuals apparently filled out. Those were available. Ms. Gilley, in a very colorful reference within her deposition, said she was basically too busy. She put them in a dadgum box and never produced them as part of this proceeding. Now, I have never heard this new argument that was made just a moment ago that, oh, those relate to a time period that may be later than what we're talking about. I'll refer the court to that. I'm not aware of that particular testimony. It certainly was nothing that came out during the summary judgment hearing, and certainly wasn't a factor within the court granting summary judgment. But even if that was true, what I do remember about her testimony was that they had a subcontractor-contractor relationship where they essentially had to prove up what these folks were doing to the contractor. And I don't think that only started at a period in time. I think I would refer the court to the record, but I think the record will reflect that there was a continual obligation to produce that type of information. In any event, even if that wasn't correct, Your Honor, the QuickBooks were not provided. The color code spreadsheets were only provided as part of the audit and audit dispute. And then we specifically asked for the WH-347 Department of Labor forms. I heard an argument from my friend earlier that they were preparing those, that they were going to produce those. I would direct the court to Mr. Gilley's deposition. He adamantly, because I got him to this point where he adamantly told me, I'm not going to produce those. I will not produce those, even though it's very clear that that type of documentation is the same type of documentation that they were contractually obligated to produce as part of the audit process.
So they claim that you had everything you needed anyway, and the additional sheet, 7,000 sheets, weren't necessary. Is that correct or not?
Is that their claim? I heard them make that
That's
claim.
kind of what I heard.
I heard
If you heard something different, go ahead and tell me.
I would have to refer the court to the record and to the briefing, frankly, because that's just not what's supported within the briefing. Just take the Department of Labor forms. There is no doubt. Now, it was after the time of audit. And again, if MVT applies, and I believe it does, it's at the time of audit that all this has to be produced. Not after you think about it later and think, you know what, I want to litigate the individual workers or the individual drivers, as it were, in MVT. Clearly, they did not produce those. Those were requested. And the reason they're significant, if you look at our corporate reps deposition that's in the record, he will explain why they're important, because they confirm, they are official government forms that go to the Department of Labor, and they confirm status. So it's a check. It's a check on normal other types of documentation, payroll type documentation that you might have, so that we can make sure that that's correct. But again, even if it is correct, and all these folks could, there's some way we could contemporaneously confirm that they were all at the casting yard, it still wouldn't matter as it relates to the way the codes work.
Because of the connected
That's correct.
issue.
That's correct. And that's how this case is just like international nutrition. And if you come down to the brass tacks of it, Your Honors, there really are the two cases that operate upon this case. And the only reason why MVT is not completely controlling is because the risk there was related to Texas drivers versus Tennessee drivers, or Texas risk versus Tennessee risk. In international nutrition, it is a very similar situation, but it's involving different risk as associated with codes. And in that,
Was there a request at the time of the audit for the Department of Labor WHL 347 forms? Or I thought that request was after the audit.
it was later. It was a check, again, to make sure that previous documentation that had been produced was accurate and consistent with what was being represented in the spreadsheet, the color-coded spreadsheet. And again, the way these policies work, whether we like it or not, it's not, remember, this is a sign of risk. Every carrier in the state of Tennessee that writes workers' compensation insurance has to participate in a sign of risk. They don't get the option. And they also have to ascribe to these specific provisions that the NCCI puts forth, whether that's good or bad. The way these policies work, it's very clear when you look at the supporting law. You have to produce all that at the time of the audit. One of the questions that was asked during the summary judgment argument was, well, they didn't request them. How are we supposed to know what they want if they don't request them? The policy is set up in a manner that you produce all of the information that supports your position, particularly as it relates to exclusion. So if you want to say, for example, here, well, all these folks were at the casting yard and that's a lower code, you're obligated to produce that information at the time of audit to support that argument. If you want to do a mini trial or try to do a mini trial as part of the audit process, even if it's not asked for, you've got to provide those daily worksheets, for example, or the QuickBooks, or the subsequent tax forms or Department of Labor forms that were requested after the audit dispute began. I do want to touch just a little bit on the specific arguments that are raised by Gilley in their appeal. I do believe that the trial court was correct in the summary judgment award. They raised the exhaustion of administrative remedies, as this court highlighted within Cook's Roofing. That's obviously not mandatory. It's permissive, which means subject to an abuse of discretion standard, the trial court in this case can say, look, particularly when you're dealing with class codes or something that technical, you should go through the administrative process because that process is better for resolving these types of highly technical disputes. The trial court's got the ability to do that the same way that they did in advanced personnel, which was Gilley's precedent that they relied upon. I would also direct the court to the fact that contractually, Gilley did not comply with the terms of their contract, the same way that the insured didn't in MVT. And then finally, even if all that's not correct, Your Honors, and I believe it is, having done this for some time, if you just look at the class codes and apply the class codes, the 522.2 and the 5213 with the scopes manual, just like at International Nutrition, that was a plaintiff's case, a traveler's case involving plaintiff's summary judgment, where the court ultimately says, Gilley, or insured, you have agreed to this process to be resolved. You have agreed to the carrier to be able to use their manuals and the NCCI guidelines, including the scopes, to determine the accurate amount of premium. And that's exactly what travelers did in this case. I'd ask for the trial court's award of summary judgment to be affirmed.
I noted in the traveler's indemnity case, the Nebraska Supreme Court case that you cited, in that case, NCCI auditor provided information on where they thought that job was classified, in addition to travelers in that case.
Yes, Your Honor.
We don't have that here, right?
Not independently from the NCCI, because that was not taken advantage of as part of the administrative appeal process.
Okay, and that would have only happened if there was administrative appeal.
I don't know if it would only happen, but that certainly would have happened, because understand the way this works is they can appeal internally. If they don't like that result, they can ultimately go to the NCCI. If they don't like that result, they can go to the department, the same way the insured did in advanced personnel, and they didn't do that. Now, I know my time is up, but respectfully, I don't think that matters that much. I mean, I think it's better for the insured's position to have an opinion basically from the NCCI. But if you look at the way the codes work in this particular case, it's a much stronger case for the codes being applied the way Travelers asserts that they should be, them even in the international nutrition case. Okay. Thank you, Your Honors.
Thank you.
Your Honors, I want to touch on one notion that Mr. Rose raised, which is this whole notion that's been pressed both at the trial court and its appeal that Gilley threw something in a dadgum box. The context of that's important. What was thrown in the dadgum box was all the records and given to Travelers. It wasn't thrown into a box and kept away and thrown away, and Travelers never had access to it. It was given to the auditor the day she was physically in person. And so that's really just a red herring for whether or not Gilley complied with the contract. Turning to an important part of the procedural stage we're at, in which Travelers contends that they alone get to make the decision. The cases of MVT, the Therico case, the King case, the rationale for the court's rulings in those cases that there was a burden to show exclusion, and again, employee exclusion is a materially different issue than class codes. The rationale for concluding that the burden was on the insured in those cases is because the workers' comp carrier almost always would have the burden, at least of a duty to defend the question of whether or not the employees were employees or independent contractors. That was the rationale that supported the holdings in those cases. In fact, in Therico, spent an exhaustive amount of time going through the rationale that even if they're ultimately determined to be independent contractors, the insurance company is still going to be on the hook for the duty to defend and thereby incur cost, even if ultimately later a court determines that legally that they're not covered under the workers' comp statute.
What your clients were constructing, this rebar-like structure, would that be considered a pile?
I don't know enough about the construction process itself, Judge McBrayer, but my understanding is these were steel cages, and they could ultimately go into a variety of contexts. I mean, here, ultimately, it ended up in a bridge, but those cages can, then the way the steel reinforcement with the tying rebar works, is they could end up in a variety of settings. My client works on hospitals, schools, hotel projects.
Well, but we know that's not where they were going, right? I mean, they were going into this bridge.
That's right, Judge McBrayer. They're going to the bridge here.
Yeah.
And ultimately, we turn back to the issue about where we are procedurally in this case. And Travelers relies on the international nutrition case. And in that case, it was an offensive summary judgment. But importantly, the offensive summary judgment was granted by the trial court and then affirmed on appeal only because the appellate court determined that the district court, as a matter of law, correctly determined that the classification code 2014 is the proper classification code to be applied to international nutrition.
And in that case, like here, there were no dispute of material facts.
There were no dispute of material facts with respect to what they were.
I guess that's what I'm struggling with is why couldn't the trial judge here on summary judgment say, okay, we don't have any dispute of material facts. We know what was being constructed, where it was being constructed, what it was going to be used for. As a matter of law, this fits within 5222. Why couldn't a court do that?
Judge McBrayer, the court could do that, but importantly, the court didn't do that. And more importantly, when you look at the text of the language of the contract itself, as it applies to the class codes at issue in this case, steel reinforcement was the scope of the contract. 5213 expressly includes steel reinforcement. 5222 does not discuss steel reinforcement. And more importantly, even if the ultimate end goal is a bridge, well, the 5222 states that if you're not working on a bridge that qualifies, and the qualification is really important under the definition of clearance, meaning that there's more than 10 feet between the ground and the bottom of the bridge, you automatically apply 5213. Thank you.
Thank you. Thanks to all of you for coming and for making efforts to help us understand. So we'll